Before we dive into today's episode, I want to let you know about an incredible CLE opportunity coming up in just a few weeks. On Friday, February the 18th, the North Carolina Advocates for Justice is hosting a CLE on handling expert witnesses in North Carolina impaired driving cases. Program chair Chaz Post, who is a close friend, we went to law school together. He was the first attorney guest on the podcast back on episode 6, has put together an incredible group of presenters, both attorneys and expert witnesses. Ron Shook is going to talk about the history of Rule 702 and tendering your expert witness. Ron was on the podcast, also a good friend, back on episode 38. Justin Hunter is presenting on cross-examination of the state's expert witness. And then we've got a group discussion that is going to be moderated by Kelly Dawkins and Anna Smith-Feltz. So a great group of attorney presenters. We also have a couple of expert witnesses that will be presenting at the CLE. Doug Scott, who was on our podcast back on episodes 12 and 13, he's going to be talking about his role as an expert and presenting on expert testimony for standardized field sobriety testing. So Doug's been doing this forever. You're going to get a lot out of that presentation. And then Dr. Andy Evans, who is on the podcast back on episodes 59 and 60, is going to be doing a presentation on attacking the ECIR2. So what more important expert could you have than somebody that is going to guide us through that process, as well as Doug through the standardized field sobriety testing? I mean, obviously key issues in pretty much every DWI case. So you get to end the day. This is a virtual only CLE. Originally it was going to be in person, but they've modified it to virtual. The bad news is we don't get to hang out together. The good news is that there's no excuse for not coming. If you can't make this CLE, it can't be an excuse that, oh, I've got too far to drive or I don't have time. Join the CLE and get as much as you can out of this kind of great group of presenters. But you have to end the day by listening to me talk about ethical marketing. So I will keep things lively and energetic so that I don't have people falling asleep late on a Friday afternoon or leaving the CLE before it's over. So I'll do my best on that front to keep everybody entertained. Again, if you make this happen, please join. For members, the rate for the CLE is $290. For non-members, you should get signed up for the North Carolina Advocates for Justice. So if you're not a member, you should be, but for non-members, it's $390. Go to go to ncaj.com, go to the education tab and sign up for the event on Friday, February 18th. Look forward to seeing you there.
Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 93 of the NCDWI Guy podcast. On today's episode, we are continuing our Masters of DWI series. Al Messer, who was on the podcast last episode 92, returns today. We talk today much about Al's vantage point and how he attacks a probable cause, a case based on probable cause. And when I suggested this as a topic for us to kind of have a conversation around, one of my thoughts was this is one of the main things that attorneys handle in terms of district court representation, the probable cause issue of attacking whether or not, in our argument being that the officer did not have probable cause to place our client under arrest for driving while impaired. So to get his kind of tips and thoughts on different aspects of what works in attacking probable cause. If you have not listened to episode 92, our last episode, go listen to that first. This is really the second part of a 2-part conversation with Al. So go listen to that first, because you'll have some backdrop in terms of Al's experience. And that was just the beginning of our conversation. It also has a biography of Al in that last episode. Again, as I said, last episode, Al is somebody that I have looked up to as an attorney here where I practice. We practice primarily in the same district, that being Buncombe County, and has been a huge example and mentor to me of how to represent clients effectively in the courtroom and how to really argue a DWI case. Go listen to episode 92 if you haven't, and otherwise get ready and enjoy.
What was the reason before you wrote? Was it, weaving? How many times did you weave? Was there a wreck? What was the basis of why they pulled you over? Whether it was bad driving or a roadblock or license check, what have you, and then or just general speeding. And then after that, talk to them and look at the reports to establish, okay, well, did they have a right to detain you? And then what kind of investigation was done there to establish probable cause? I have a case coming up, soon for trial, where one of the officers, he's a sheriff's deputy, he's sort of notorious for not having video camera. I think he's even told people before that he sometimes has turned off his in-car camera before. And you probably know
I know who you're talking about.
and sometimes I take it with a grain of salt, and I firmly believe most officers are truthful and honest and hardworking people. But sometimes I have to take it with a grain of salt. Maybe they misremember, or there's maybe some exaggeration there. But he says, of course, the client was speeding, which under at least the National Highway Transportation Safety Administration, speeding is not an indicator of impairment, a clue of impairment. But then he talks about you're all over the road, and of course it's just his word versus the client's word. And then he gets pulled over, and my client's standing there on his body camera, and standing, to us, it looks perfectly still, almost like a statue, not weaving, and does relatively well on the sobriety tests. There are a couple of clues that the officer notes. But one of the big issues is he's doing this on gravel, on sort of a slant. And so we got one of the experts that we use involved that, that people use. Like Scott, I think you're familiar with him.
Yes, yeah.
And so we're using him as an expert to establish some of the protocols and procedures weren't properly followed. And so thus some of these ride tests that were performed.
Was that in Superior or District Court that you?
Right now we're in District Court.
Okay.
So again, so he's doing a lot of this on a gravel. And again, I think for the HGN, of course, is most times it's like 6 to 6 clues. And then maybe 2 clues on the walk and turn, and maybe 1 clue on the one leg stand, if I can remember correctly. But again, he's on gravel, and he's right beside a pavement. Our expert says he should have been doing this on pavement instead of gravel. He's not. His speech doesn't appear to be slurred. And then one of my big indicators about, sort of, is this a good issue for probable cause? This particular officer, in my opinion, if they blow relatively low on the PBT, there's a blood test.
Yep.
If they blow pretty high on the BBT, they take them down to the jail for a breath test. And because if they blow, say, like a 0.8 on the PBT, again, just my personal opinion, I think the officer is like, well, I get them to the hospital quickly. I don't have to go through the waiting procedures for the breath test. I can get the blood, and they have a right to establish what test they get. But if it's a higher, then I don't think there's that concern that they're going to end up blowing under the legal limit.
Right.
That's something we have to look at, because and the officer, of course, I don't think they'll necessarily admit that, but what we look at is are they blowing so low? So you normally take a person to get a breath test, but in these particular situations, when they blow a 0.8 or 0.9, and then on those particular situations, you take them to the hospital, or are you not taking in consideration the breath test reading, the PBT reading, to establish probable cause?
Yes.
This law, and specifically State versus Overrocker from the Court of Appeals, says specifically you can't use the portable breath test numerical reading to establish probable cause. Now, you can use it to, I guess, corroborate your findings, your other findings, but a lot of times, I feel and believe, and I think some colleagues do, that these officers a lot of times establish PC based on the numerical reading.
Yeah. Well, and I know specifically who you're talking about. And I think that in terms of experience and kind of having enough of cases under your belt as an officer, you start to realize what you're kind of supposed to say, not supposed to say in the courtroom. You get better at your investigations. Hopefully you improve based on further training, based on being in the miserable experience of getting cross-examined. So hopefully you do get better. But I've never really kind of thought about what you had just said in terms of using that to attack PC, because I've definitely had several situations where I thought the PBT was what was the deciding factor in getting blood tests or breath tests. And I think, for most people, I can't remember what the percentage is, but like 80+% of people, if you took blood and breath at the same time, the blood would come back same or higher. And so, I think that that's kind of going into that same kind of consideration of trying to kind of get the end result of getting a 0.08 or greater alcohol concentration. But obviously, if the 0.08 number from the PBT is what is driving that decision to get blood or breath, or the PBT itself is what's driving that, I think that that's definitely then able to be used in terms of attacking PC. So I think that's a really powerful way of challenging that.
Yeah, years ago, I had the same officer that would get blood if they blew low, and there were a couple cases where the breath, they would get breath, just take them down to the jail and do the intoximeter. And then there were a couple cases where the results were under a 0.08. And so the last several years, when again what I'm seeing from this officer is if they blow low on the PBT, they're typically being taken to get blood, because again, when once you get arrested and you take them down to the jail, they have to get processed through the jail. Then you have to go through the advisement forms and the probation period, and they have a right to call a witness. And then if they do that, then it has to be extended, to 30 minutes. And so if they blow up 0.8 on the PBT, this is just sometimes what I think might be going through some people's minds is, well, gosh, it could be an hour or more before I get a breath test, and under the legal limit. And again, they're doing nothing wrong really, because as far as designating what test, the statute gives them every right to designate what test. But what I get at sometimes is, I think you're using that breath, that PBT to establish probable cause, and it's clear you can't do that.
Right.
And there's some officers, and a lot of courts allow it for whatever reason. But for example, and I see this all the time, license checks with say troopers. I drive up to a license check. The officer walks up, has a PBT in his hand, smells alcohol, says, "Hey, blow on this."
Right.
Well, you're really not supposed to do that. And then of course, if they blow 0.8 or higher, then it goes into a deeper investigation or an arrest. Or a lot of times, we're seeing they do the HGN, a PBT, and that's it, and no other physical tests. And there's an unpublished decision years ago that talked about that. I think it was State versus Sewell, SEWELL, I believe, was unpublished, about the person, I think, went through a license check, had odor of alcohol, maybe admitted to drinking, positive on the PBT, but really no other, and I think HGN.
And HGN, yep.
HGN, but no other clues. And so a lot of cases I had similar to that. I would try, even though this was an unpublished decision, I would still try to say, hey, judge, that it can still be persuasive authority, taking consideration, this case. because you have similar facts, just like in that case where you have the odor, no bad driving because it's a license check, HGN, and there's all sorts of, I guess, disputes about how accurate that is. And then, the PBT, and that's all I have. And then there's some other cases that aren't great and can establish PC for some, just a few things that show that the officer sees. So it's sort of, probable cause is just not a very high threshold. It's a tough standard to beat, but occasionally it happens.
Yeah. And I think it's one of those that is so frequently used on DWI cases because it's one of the primary challenges that you can go after to keep that blood or breath test result out of evidence. I mean, it's one of the main things that we use in practice. One of the things that you kind of taught me several years back, and I mean, I don't think that this was specific to probable cause on DWI cases. It was just more wherever you have multiple officers, but was this kind of idea of sequestering state witnesses. When you have multiple witnesses that are involved in establishing probable cause, is that something that you kind of routinely do? Does it depend on the circumstances? What does that kind of difference look like when you have one officer that does the arrest and then another officer arrives on scene and does a PBT and then the DWI task force officer comes out? What's different about attacking PC when you have those multiple officers involved?
Well, I do that a lot with DWI cases and non-DWI cases. I did that yesterday in this case that I tried, because the thinking there is you get the person on the stand, say the main officer or the main witness or what have you, and they say they says happened. Well, if other witnesses are there, there's just that concern that if they hear what the main witness says, then when they get asked questions, they're not sort of to track similar lines. So I'd rather them not hear what the main person says. And so that comes with officers too, where I've had many occasions where I sequester witnesses. I get, just the main officer in. He says, yeah, smelled alcohol, slurred speech, red eyes, wobbling all over the place. Then second officer comes in. Well, no, I didn't really notice any kind of unsteadiness on the feet. I couldn't smell any alcohol. So you get some inconsistencies and some contradictions there. And so that's why a lot of times if I can, I try to talk to each officer separately outside the presence of each officer. Sometimes I don't do that for a variety of reasons, but if there's multiple people involved, a lot of times I will sequester witnesses, because you'll be surprised on how many contradictory statements. And that's where you sort of attack, okay, reasonable doubt, because this person saying this, you have this person saying that. Can I squeeze reasonable doubt out of that if I'm in a trial? As far as PC goes, it's in the light most favorable to the state. So, there I get, well, yeah, Judge, I understand the evidence in the light most favorable to the state, but that evidence has to be reliable evidence. And so when you have two contradictory statements from two officers, how is that reliable evidence? Therefore, how can it be in the light most favorable to the state based on this reliable evidence? Because it can't be reliable if it's contradictory.
Right.
A lot of times you lose those arguments, but that's a lot of times what I do.
Yeah, no, I think that is so powerful, and it is amazing how many times there is contradictory statements. I think sometimes it's because of just complete lack of memory. I mean, these things are, 6, 12 months removed from when they were charged. And so, it would be kind of a miracle if there wasn't inconsistency. It'd be kind of a miracle. And, for whatever reason, I don't see, most officers where there's a multiple officer case get together 10 minutes before a trial and say, hey, what do you remember happening about this situation? There's not that kind of like community refreshing of the recollection before trial. So everybody kind of walks in there somewhat blind and, just does, again, whether it's, I don't generally see that there's kind of any intentional, misremembering of things, but people are just going to remember the situation differently between one officer and the next. And especially if they don't have any notes that help to, kind of establish what that looked like, it's going to be a problem for them. So,
yeah. And a lot of times, if it is multiple officers, again, depends on the case. Sometimes I will ask the officer, well, hey, who'd you talk to about this case? Did you talk to this officer before this trial? Did you guys get together, discuss it? Sometimes they did. Did you review each other's reports? What'd you talk about? Just to, especially if it's been a long time. And again, I don't think there's this large conspiracy to their acts of this, concoct evidence. I don't believe that. Like I said before, I think, most officers, just like, attorneys, are hardworking, honest people, but sometimes make mistakes. Sometimes they misremember. That's why I have to write down things all the time.
Right. Yeah, exactly.
Remember, with
the
stuff. So.
Well, I've got two more questions for you, Al. If you have, do you have a couple more minutes?
Sure. Yeah.
Okay. Yeah. So I think, in terms of the probable cause side of things, what if you get a situation where the PC is probable cause motion is granted, and you're assigned to write the preliminary indication or draft the preliminary indication for the judge to sign. What are any suggestions or tips that you have in terms of drafting the preliminary indication?
So I think one of the biggest things is to be very specific and be very detailed, and make sure you have enough specific findings, because again, the prosecutors are going to normally object, I guess, to the findings, which will let a Superior Court judge have de novo review. In the past, a lot of times I've tried to put in there, the prosecutor, a little line that, have the prosecutor sign that I agree to these findings. A lot of times prosecutors won't do that. But just be as detailed as possible, knowing that this could get reviewed, and especially have to have another hearing up in Superior Court. But so a potential Superior Court judge reading this will know, hopefully with some decent specifics, why the motion was granted, and might lead them into why there's a good chance, it should be upheld on appeal from the state, if that makes sense.
It does. Yeah, no, absolutely.
Yeah. So I do try to be very detailed, factually detailed, write down what the judge says as much as I can. Sometimes we record it so we can be very detailed. Yeah, and some district court judges are extremely detailed. There's one in particular that takes a lot of notes, and she's really, really detailed. There's another Superior Court judge that doesn't take really a lot of notes, but then he just says things, and you just try to write it down. But that's why I just try to put as much specific detail as possible. Not that I would say is favorable to my client, because it has to be objective, and has to be what was found truthfully. But you want to make sure that it does track the judge's findings, which ultimately was favorable to your client.
Right.
So,
I think in any jurisdiction where the state might consider appealing a preliminary indication granting the motion to suppress, some jurisdictions, if the motion to suppress is granted, it's dismissed on the spot. It's just like one less thing now for me as the DA in district court to deal with. But in places where the state is more likely to appeal, I think having as much specificity, like you said, as to the findings of fact is so powerful. And, in a case where you're able to record, and I regularly record district court trials, I'll even sometimes attach the audio of the district court recording with a specific time frame as to when each statement that I put into the preliminary indication was mentioned. And then when I go talk to the DA, if you can get them locked in, and it's tough sometimes to get a DA to lock in on the findings of fact. But if you say, here's the findings, here's, where they were mentioned in the record, which findings, if any of these, do you disagree with? And I'll go change them before we get the judge to sign off on that. Like you said, if you can put in there something where the DA specifically signs off that, the state agrees to the findings and the, in the preliminary indication, you have a much better chance, in my opinion, in Superior Court at that point, because now the Superior Court becomes a court of appeals as opposed to a a trial court kind of rehearing the motion, and that gives you a much higher chance. I had a case a couple of years back where we won in a district court, got the preliminary indication kind of as to both reasonable suspicion and probable cause, granted, drafted that, went up on appeal to Superior, and the Superior, we basically kind of got the DA to agree. And I mean, there really wasn't anything to dispute. Some of the facts weren't actually all that, what you wouldn't consider a slam dunk for the defense, but looking at it as a whole, it was very clearly the right decision by the district court. But the Superior Court judge basically said, well, these facts aren't disputed. The trooper was sitting in the courtroom in Superior Court, and he said, well, the facts aren't disputed, so there's no new hearing. And then basically said, if this was me hearing this evidence in district court, I'd have denied the motion to suppress. But I'm kind of sitting here to try to figure out what, if anything, the district court judge did wrong. I can't really see that there, it's a difference of opinion, but, I'm not going to, without hearing the evidence myself, I'm not going to overrule. So that was like the most clear place that I've experienced personally, where it was like if you can bypass the new hearing in Superior Court, you have a much higher chance of success.
Yeah, but you'll find a lot of times when the state does appeal, they do object to the findings, and that's why I do try to get the DAs to, hey, these are the findings. Do you object to these findings? This is what happened. Well, yeah, this is what the judge found. I might not agree with it.
Right.
But these are the findings. So, but I think the biggest thing is to be very specific with as much specificity. Sometimes my orders or my proposed orders are pages long, many paragraphs, just so I can put enough specificity in that order. And a lot of times when you draft it, sometimes the DA will look at it and like, yeah, maybe I don't need to appeal this. This might be a good case. You might be able to talk them out of it. And real quick, also, I may have a good PC case, but I also may have a really good tribal case.
Yes.
And so there's some situations where I have to think, yeah, I can go to PC and then win a good chance, and then the state may appeal that, or I can just go straight to trial and try to get it not guilty, and then they can't appeal it. And so sometimes I've depends on the strength of the case, in my opinion. Sometimes I'll forego doing a motion to suppress and just go straight for in the trial.
Yeah, I agree.
So that's one thing. And then there's some judges that if you do a motion to suppress where you argue no reasonable suspicion, no probable cause, some judges will just hear, okay, I want to hear reasonable suspicion, and then counsel, I want to hear argument on that. And so I have one judge particularly granted my motion on reasonable suspicion, and then the state, then he says, yeah, there's no reasonable suspicion. And so we didn't even get to PC. So we just, in the state appealed that. We went to Superior Court. The judge up in Superior Court found there was reasonable suspicion. Then we came back and we had to do PC. And then he granted PC, my motion for no PC. And then I think we went up, and then the judge may have found there was no PC, but then we went to trial and we won the trial.
Right.
So sometimes it just hands back and forth a few times between district court and Superior Court.
Yeah, no, I think that is, definitely one of the tactical decisions that has to get made in a situation where you have a good tribal issue, maybe particularly where like driving is in question. Well, yeah, we could put this through a PC issue, but maybe in front of the judge that in the courtroom that day, it's like, well, this is going to be a great Eldred or Kraft case, and so we might as well just kind of throw our cards in on that front and let that fall where it might. So I think that is a really important kind of tactical decision. Well, I guess I kind of like to maybe finish with this, Al, in terms of any trial tips that you have for young lawyers. Again, I definitely have learned an incredible amount from you over the years since day one, pretty much of my practice. In terms of young lawyers, that don't have this, mass amount of trials under their belt, what would be, anything that you would offer in terms of advice for the young attorney that wants to try cases?
Yeah, I think the number one for me, and I don't always do this, but sometimes it's key, and it's where I've been very successful, is preparation. A lot of cases, whether it's a DWI or a homicide case, if I'm going to trial, I want to know that case better than the prosecutor.
Yeah.
And so especially there's been some homicide cases where I know that thing up and down, whether it's 1,000 pages or 5,000 pages or more of discovery. I'll have read every single page. I'll be able to pick out some points, and I'll know some, and I'll be able to attack certain things. And a lot of times the prosecutors won't be as prepared. And so going in, I think being as prepared as possible, because officers, DWI cases specifically, it may be a year ago since they did this case, and they're going to walk to court, look at their report for maybe 5 minutes, and then jump on the stand. And so, I want to make sure I've looked at all the reports. I want to look at the body camera. I want to talk to witnesses. I want to do this, do that, to make sure I know the case better than the officer, so I can be prepared to argue certain things that they may not have a clue that I'm going to argue. And more often than not, but there are times where you get so busy and you have so many cases, and it's hard to be so thoroughly prepared. Sometimes you're in a crunch before the trial, just reading all this stuff, getting prepared as possible. But I think that's probably the number one, is just know your case, be as prepared as possible, because if you're more educated, you know that case better than the prosecutor, a lot of times, you can just argue these points and the prosecutor won't have a clue how to respond. And they won't have looked at certain things you've looked at. That's probably the biggest key is preparation.
Yeah, I love that. I think one of the real values of that for young lawyers is that, specifically when it comes to DWI, the breadth of legal issues that kind of fall within DWI is so vast. And so as a new attorney, it is sometimes, I think, daunting to try to figure out how to untangle all of these legal issues. I'm still, learning on a daily, weekly basis something new about DWI, finding a new case or a different way to argue things. And so there's just this kind of never-ending ability to improve on the law side of things. And so as a new attorney, where you're still kind of getting all of that under your proverbial belt, the way I think to kind of separate yourself on a case is to know the facts like mad. And so that preparation of being able to look through all of the discovery, watch every second of the dash cam and body cam that was done. And some of these things are an hour and a half long, and a lot of periods of nothing going on, but you might catch some nugget where the officer, in the jail, goes over to some guy and talks to him a little bit about the case. Another officer or bailiff in the jail or whoever it might be talks to them about the facts of your client's case. Your client's off camera and says something kind of damning about what the circumstances were that led to the arrest. Going out and visiting the scene of the stop or the scene of the accident, and just having that in your brain where all of this took place is a huge advantage. I don't really think that can be understated, how much of an advantage that point is. Writing out your cross-examination questions. I think all of those things are such a easy place. If you don't have a lot of experience under your belt, having that preparation can really cut out a lot of that kind of years of separation.
Yeah, I agree. And like you said, the lawyer that you had on last time about sort of a free-flowing examination, I agree a lot with that. But what I do is I typically, whether it's a DWI case or a homicide case, for the main detective or main witnesses, I do have sort of an outline of a diagram. I typically like to write down some questions, but I don't get in my mind, hey, this is a script that I have to follow, because I start these questions, and it may take, if I have 100 questions, I may start question one, and I might have to bounce down to question 100 or questions I didn't think of. Just be ready to, just to go wherever it takes you. But
exactly.
but generally I can go back and make sure I've covered all the questions I wanted to, but I don't have to be stuck in this monotonous little script. Because again, especially if it's in front of a jury, you don't want to be like a robot, because sometimes juries get bored looking at that monotony. And so you want to have this interaction with the officer and this free flowing conversation and make your points and make sure that's emphasized to a jury. So I really agree about the free flowing, but I still think it's important to maybe prepare on what specific questions or what topics you need to cover. And then, out of your case, just pick your points that you need to argue, that you want to try to establish that's a defense for your client.
Yeah, I love that. I think that's so powerful. Well, I think we maybe have hit a good place to stop out. I can't thank you enough for coming on and sharing your many years of wisdom with with my listeners. It really has been you're probably the most helpful in terms of any attorney that just from day one, being a mentor and being somebody that I could kind of talk to, bounce cases off of, get advice from. So I feel really humbled to have you on the podcast and sharing your information with everybody else like you have with me. Yeah,
I appreciate it, man. Well, these days, I'm getting, as I get older, and a lot of times it's been years since I've handled a certain kind of case, I like, I forgot this. So now I'm in the process where I have to ask people.
Yeah. No, I mean,
refresh my memory.
I think that should be a healthy sign for anybody that is listening. You never get too experienced in these things where you just know it all. It's not going to happen.
I think for new practitioners, if they're a member of a listserv, I often post questions on a listserv.
Yeah, exactly.
It sounds like a stupid question, but for the life of me, I can't remember something off the top of my head. So I post a question, or I call up a colleague, or like I did with you the other day, I text you and say, "Hey, I'm having a hard time remembering this. Can you remind me?" And there shouldn't be any pride there. I think it's
actually kind of interesting, because on most of the listservs that I am a part of, it is like some of the most experienced attorneys that are the most frequent posters of questions. And I think that's just because there's a comfort level of being like, it's okay if I don't know it all. I don't feel like people are going to look down on me, but certainly for new attorneys, tap into that, take advantage of it. Nobody's going to think you're silly or ridiculous for asking a question. So
yeah, exactly. And now sometimes if I ask a question and nobody responds, I'm like, was that a stupid question?
That's right. Either that or nobody else knows the answer. So
that's right. Probably, maybe a little bit of both.
Well, I appreciate it very much, Al. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you're listening on, I would greatly appreciate it.